Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. For today's live stream, we are going to go through the freshly issued COVID-19 mandate. Technically it comes down tomorrow, because that's when it's formally published, but the unofficial draft was released today. It will be published formally tomorrow in the Federal Register, but we're going to go over this mandate in full, describe what it says, describe what it's saying, what it makes you doing, and what it doesn't make you do. And we're going to look over the legal authority, and we're going to discuss it from a variety of positions to try to understand what's going on and try to have the best legal analysis that we can. So it's a good place to know what are employers supposed to do, what are employees supposed to do, what liabilities for the employer, what liabilities for the employee, and is any of this legal? These are all very, very good questions. So we're going to figure out that, and we're going to do it together. So let's just go ahead and get started. So this is the formal thing that came down tomorrow and formally publishes tomorrow. So this is an emergency temporary order, which is what ETS says, emergency temporary standard. So it is my understanding that OSHA does not issue these things. I think they might have issued one like ever. I might be making that up though, but it's my understanding these things are rare. So this is an emergency standard based on the requirements of the Occupational Safety and Health Act, which is the OSHA Act or Act, and legal precedent arising under the Act. Under Section 6C1 of the Act, OSHA shall issue this emergency standard if the agency determines that employees are subject to grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards, and an ETS is necessary to protect employees of such danger. I'd simply take note here that the nature of the danger is not from the workplace. Normally, when you're thinking about, for example, things that might be toxic or things that might be harmful or things that might be hazards, you're thinking about things in the workplace. A new chemical, a new dangerous situation that has erupted, some sort of thing that's present at the workplace. That would be the nature of the hazard at the workplace. This is a hazard that is not limited to the workplace. It's a strange kind of hazard. It's a hazard that exists everywhere. These legal requirements are more fully discussed in pertinent legal authority, which I'm looking forward to discussing. The ETS does not apply to workplaces subject to a different executive order or regarding coronavirus disease 2009 vaccines for federal contractors. So the U.S. government, Biden, has already issued a separate mandate with respect to federal employees and federal contractors. So they're not subject to this because they're subject to something else. In addition, OSHA will treat federal agencies' compliance with the executive order and safer federal work task force guidance issued under Section 4E of the order and Section 2 of the executive order as sufficient to meet the obligations. So if you comply with that stuff, you're good with us, which makes sense. COVID-19 has killed over 725,000 people in the United States in less than 2 years and affected millions more. It's a little bit putting the genie back in the bottle. Oh, now we have to issue this emergency mandate because of this brand new hazard. There's something odd about that. The pandemic continues to affect workers and workplaces. Continues to, being I think the notable language in that sentence. While COVID-19 vaccines authorized or approved by the FDA effectively protect vaccinated individuals against serious illness and death, unvaccinated individuals remain at much higher risk of severe health outcomes from COVID-19. Those people could get vaccines, though. So if it doesn't really pose a risk to the vaccinated, and the unvaccinated can get vaccinated if they wish, sort of like where's the problem in some way. Further, unvaccinated workers are much more likely to contract and transmit it in the workplace than vaccinated workers. One would think that's true. But again, it doesn't pose a threat to the vaccinated workers. They just told us that. OSHA has determined that many employees in the U.S. who are not fully vaccinated against COVID-19 face grave danger from exposures to COVID in the workplace. These findings of grave danger is based on severe health consequences associated with exposure to the virus, along with evidence demonstrating transmissibility of the virus in the workplace, along with like literally everywhere else, and the prevalence of infections in employee populations. Is that different than the prevalence of infections in non-employee populations? I'm just curious. OSHA has also determined that this emergency order is necessary to protect unvaccinated workers from the risk of contracting COVID. Why? They can get the vaccine if they want to, and they've already admitted that that would be sufficient to protect them. At the present time, workers are becoming seriously ill and dying as a result of occupational exposures to COVID-19, when a simple measure, vaccinating, can largely prevent those deaths and illnesses. Sounds like it might be a good idea for you to get it then. If you don't, and you get sick, I'm not sure how that's on anyone else other than you at this point. The workplace is not creating the hazard. That's what the workplace is not, failing to install a railing or failing to install steps at the right height, or failing to make people wear hard hats, or any of the numerous other things that a workplace might fail to do that poses a risk. The risk that exists is not a creature of the employer, unlike the lack of a handrail. There's nothing stopping them from installing the handrail. In fact, they're required to. So the failure to do that is a problem, and it's also on them because they could do it. Yeah. At the present times, workers are becoming seriously... Okay, we read that. The emergency order protects these workers through the most effective and efficient control available, vaccination, and further protects workers who remain unvaccinated through regular testing, use of face coverings, and removal of all infected employees from the workplace. OSHA also concludes, based on enforcement experience during the pandemic to date, that continued reliance on existing standards and regulations, the General Duty Clause of the OSHA Act, which basically says that employers have a general duty to instill safety in the workplace, and employees have a general duty to comply with that. That's the General Duty Clause. Please make the workplace safe. And workplace guidance in lieu of the emergency order is not adequate to protect the unvaccinated from the grave danger of being infected by and suffering death or serious health consequences from COVID-19. Okay. OSHA will continue to monitor trends in the infections and death as more of the workforce and general population become fully vaccinated against COVID-19. Where OSHA finds grave danger from the virus no longer exists, or new information exists, a change in measures is necessary, OSHA will update this order as appropriate. So you'll no longer be required to take the vaccine anymore at some point in the nebulous, undefined future. Of course, if you've already taken the vaccine, it's a little bit hard to unring that bell. That'll be good. Let's come up with an anti-vaccine. That'd be good. The ATS applies to employers with a total of 100 or more employees at the time. Why 100? I hope they will specify. Where did we get that number from? Just out of curiosity. In the light of unique occupational safety and health dangers presented by COVID-19, and against the backdrop of uncertain economic environment in the pandemic, OSHA is proceeding in a stepwise fashion addressing the emergency. OSHA is confident that employers with 100 or more employees have the administrative capacity to implement the standards requirements promptly, but less confident smaller employers can do so without undue disruption. Okay. But the thing is, if it's truly a health hazard, right? If it's truly a hazard, which is the entire premise of this thing. So we don't want to bind workplaces under 100 because we don't think they have the administrative capacity to deal with it. Okay, please tell me any other OSHA regulation this applies to. If you have a construction site and you have 1,000 workers, or you have 10, I don't know for sure, but I'm pretty sure the standards are the same. So I don't know what this is. Oh, it's only 10 people. It's only 10 people at this particular work site, so they don't have the capacity to administer. So some of these regulations that we have, it's okay. You can ignore those regulations. 10-person construction company on your 10-person on your build. You can ignore those safety regulations. That's okay, because you don't have the administrative capacity to make sure those regulations exist. Please show me where that is a thing. Hey, the 10-person company with 10 people on the construction site, you don't need to wear hard hats. You don't need those railings. It's too much an administrative burden. Sure. Nah. OSHA needs additional time to assess the capacity of smaller employers and is seeking comment to help the agencies make that determination. So they've asked for a request of comments, by the way. So if you'd like to officially bitch at the OSHA, you are now invited to do so. You can officially bitch to them in writing and tell them they're commies if you're so inclined. The address information is contained in the regulation. Nonetheless, the agency is acting to protect workers now and adopting a standard that will reach 2/3 of all private sector workers in the nation. But it's a major, major threat that's killed 700,000 people. So it's totally okay that our regulation is only going to protect 2/3 of the workforce. The other third can eat it. Including those working in the largest facilities where the most deadly outbreaks can occur. I mean, I don't think that's true. I think the breakouts are equally deadly. It's just that it impacts more people, presumably at a larger workplace. The agency has also evaluated the feasibility of this and determined that the requirements are both economically and technologically feasible, as outlined in the feasibility section. I look forward to this. How this is economically feasible, particularly when it comes to the testing alternative. The specific requirements of this are outlined and described below. Okay, so here's your official how to bitch at OSHA. If you'd like to officially bitch at OSHA in writing to the federal government, here's how you can do it. This serves as a template or proposal for the final standard. So this is a temporary emergency standard, or apologize, let's try that again. It's a temporary final standard. There will be a final standard, so you can bitch before that happens. Accordingly, OSHA seeks comments on all aspects of it and whether it should be adopted as a final standard. Do you have any comments about whether it should be formally adopted as a final standard? OSHA would like to know. OSHA encourages commenters to explain why they prefer or disfavor particular policy choices and include any relevant series, experiences, anecdotes, or other information that may help support the comment. In particular, OSHA seeks comments on the following topics. Employers with fewer than 100 employees. As noted above and fully discussed in the summary, OSHA has implemented a 100 employee threshold for the requirements of the standard, leaving 1/3 of the workforce in the wind, to focus on the companies that OSHA is confident will have sufficient administrative systems to comply quickly. 1/3 of workplaces don't need hard hats anymore. This agency is moving in a stepwise fashion on a short timeline necessitated by COVID-19 while soliciting stakeholder interaction and additional information to determine whether to adjust the scope to address smaller employees in the future. As I understand it, the Biden administration already said today that they're looking at this going to smaller people. I don't know if this is a boil the frog kind of situation or whatever, but OSHA seeks information about the availability of employees with fewer than 100 to implement this. Have you instituted vaccine mandates with or without alternatives or requirements for regular testing? What have been the benefits of your approach? Why don't those benefits translate to larger workforces is also a question. What challenges could you have or foresee in implementing it? Is there anything specific to your industry or the size of the business that poses a particular obstacle? How much time would it take? What kind of cost would you incur? And how much would it cost for you to implement? Significant risk. If OSHA were to finalize the rule in a final regulation based on this emergency, it would be a standard adopted under 6B of the OSHA Act, which requires a finding of significant risk. One could seriously debate how significant the risk is given the relative death numbers and so forth and so on, but that's a different discussion for a different day. As discussed more fully in the Permanent Legal Authority, which we'll get to eventually, This is a lower showing of risk than grave danger. So just a significant risk, not a grave danger risk. But so I don't understand this at all. If you have a grave danger, you necessarily have a significant risk. Significant risk is lower than grave danger. So if you have significant risk, it doesn't imply grave danger. But if you have grave danger, it necessarily implies significant risk. So please help us find the lower burden of significant risk when we've already determined there's a grave danger. I wouldn't think it would be that hard. How should the scope of this rule be addressed to change the significant risk? Should portions of the rule, such as face coverings, apply to fully vaccinated persons? Do fully vaccinated persons have to wear face masks? OSHA has determined that workers who have been infected with COVID-19 but not been fully vaccinated still face a grave danger from the workplace. So this would be people who have previously had COVID and have recovered. You too are a grave danger. This is an area of ongoing scientific inquiry. Given scientific uncertainty, so I love that already, we have determined it's a grave danger. We have determined this despite the fact it's an ongoing inquiry and there's scientific uncertainty. But we're not uncertain. Where we're drawing this certainty from is less clear, I'd like to note. Given the scientific uncertainty and limitations in testing for infection immunity, so basically the tests are crap, OSHA is concerned it would be infeasible for employers to operationalize a standard that would permit or require an exemption from vaccine or testing and face covering based on a prior infection. Is there additional scientific information on this topic that OSHA should consider as it determines whether to proceed with a permanent rule? Why does it matter in some sense? Because once you have the vaccine, you can't undo it. So the temporary final rule goes into effect full effect on January the 4th. So let's suppose that our friends at OSHA take, 3 months. Let's suppose they take 3 months to determine that, as it turns out, we don't need the vaccines anymore. So how about all those people in the meantime, though? In particular, what scientific criteria can be used to determine whether a given employee is sufficiently protected against reinfection? One would presume the studies that are incomplete that you are not relying on because they're incomplete, even though you're sure. Are there temporal limits associated with this criteria? Do you require employees to provide verification of infection? If so, what kind of verification do you accept? That would be PCR testing, antigen testing, etc. What challenges have you experienced, if any, in operationalizing this? Experience with COVID-19 vaccination policies. Should OSHA impose a strict vaccination mandate? All employers require to implement mandatory policies. If it's truly a grave threat, how is it less a grave threat at the under 100? So the logical answer to this would necessarily be yes. It would have to be yes. It would have to be yes. If it's a grave danger at places with more than 100 employees, how is it not a grave danger at under 100? Because it's the same thing. So the answer would necessarily have to be yes. We have to regulate all the people. Nothing else will be logically consistent. Was vaccination mandatory or voluntary? Do you offer vaccinations on site? What costs of vaccination do you cover? What percentage of your workforce is vaccinated? Do you offer paid leave for recovering from a vaccination? If vaccination is mandatory, have employees been resistant? If so, what steps were required to enforce? How did you verify these employees were vaccinated? Are there other reliable means of vaccination verification not addressed by ETS that should be included? Did you allow attestation, which is just basically swearing it's true, when the employer could not find proof? And if so, have you experienced any difficulties? What would those be? Have you experienced any issues with falsified records? If so, how did you deal with them? Have you experienced a decrease in infection rates or outbreaks as a result of implementing the policy? as a result of implementing the policy? How would you know that? Correlation does not imply causation. You might have experienced a decrease after, but how do you know it's because of? If you received any requests for reasonable accommodation, what strategies did you implement? For example, teleworking, working in isolation, regular testing, and the use of face coverings. COVID-19 testing and removal. OSHA seeks information on COVID-19 testing and removal practices. Do you have a testing and removal policy in your workplace? And if so, what does it require? How often do you require testing? What kind of testing do you use? For example, at-home test performed at laboratory, test performed at your worksite? What costs have you incurred as a result of these policies? Do you have difficulty in finding adequate availability of tests? How often? Have you experienced any issue with falsified results? And if so, how did you deal with that? Have you experienced other difficulties in implementing a testing and removal scheme, including the length of time to obtain the results? Do you offer paid leave for the testing? How often have you detected and removed COVID-19 positive employees from the workplace? Do you provide paid leave and job protection to those employees you remove? Should OSHA require testing more often than on a weekly basis? So that weekly testing, how about more than weekly? How about twice a week? How about every day? How about multiple times a day? How about at the start, lunch break, and end of every shift? As discussed in the summary for face coverings, someone, I don't know who that is, someone released a specification standard on February the 15th to establish a national standard baseline for barrier coverings. So whoever this is, other agency or whatever, issued a standard on what face masks mean, at least in the workplace, apparently. Should OSHA require face masks meeting this standard instead of face covering specified? So instead of the face mask we say, how about the more stringent face masks that meet this particular standard? If so, should OSHA also require face coverings meet with NIOSHA's workplace performance or workplace policy criteria? Are there particular workplace settings in which face coverings meeting one standard should be favored over another? Why not just make sure they meet both at the same time? I mean, if it's a grave threat and all, right? Are there alternative criteria OSHA should consider for face coverings instead of these standards we just discussed? Is there sufficient capacity to supply face coverings that meet these standards? Other controls. This emergency standard requires employees to either be fully vaccinated or be tested weekly and wear face coverings, and presumably they're going to tell me at whose expense at some point, based on the testing type of policy their employer adopts. Those testings, by the way, are not free. I believe they go for about $50 a piece. If you have to test every single week, right? If you have to test every single week, and you have 99 employees, then that would be, what's 50 times 100 minus 1, so that's 49.50, like every week. And if you do it more than once a week, then it would be however many more times a week times that, right? The emergency standard will stop short of requiring full suite of workplace controls recommended by OSHA and the CDC. Why? OSHA recommended, this is a weird phrase. This is a weird turn of phrase. OSHA has recommended things, but OSHA themselves are not going to adopt their own recommendation. But the thing that OSHA recommends but isn't adopting at this time includes distancing, barriers, ventilation, and sanitation. Well, sanitation just seems like a good idea overall, to be quite honest. As OSHA explained in the need for this, OSHA has determined that it needs more information before imposing these requirements on the entire scope of industries and employees. So look forward to plexiglass being installed between employees at every business, everywhere. Fun. OSHA is interested in hearing from employers about their experience in implementing this full suite of protections. What measures have you taken to protect employees in your workplace? Are these controls that you attempted to deploy but they've been found ineffective or infeasible. What are they? Why did you conclude they were ineffective or infeasible? For example, are there particular aspects of your workplace or industry that make these controls infeasible? Do you require both fully vaccinated and unvaccinated to comply with these controls? How do you experience a reduction in infection because of the controls? Educational materials. Have you implemented any policies or provided information that's been helpful in encouraging an employee to be vaccinated? I don't like this question very much. What's the point of the question? Have you distributed literature or other information that has been helpful in encouraging? Why does it matter? We just put in place a mandate. So why does it matter how well we've been able to encourage people up to this point? Because we're going to make them do it. The time for encouragement is over, man. Do you have any experience or data that would inform OSHA's estimates in economic feasibility or any of the assumptions or estimates used in OSHA's identification of number of hospitalizations prevented and lives saved from this impact? And then there's some citations. So yeah, those are some of the questions that OSHA would like answers to. So once again, you can give OSHA their answers. You can go to the Federal Register starting tomorrow, and you can provide your answers to these and other questions. These are the questions OSHA wants answers to, but you can supply your own answers to other questions. You know, I just simply remind you that it is a matter of public record. So as long as you're okay with, everyone knowing your comments, but, go nuts. The purpose of the Occupational Safety and Health Act is to assure as far as possible every working man and woman in the nation safe and healthy working conditions. That seems good as a general proposition. To this end, Congress has authorized the Secretary of Labor to promulgate and enforce occupational safety and health standards. These provisions provide bases for issuing these standards under the law. Once OSHA has established as a threshold matter that a health standard is necessary under either 6B or C, that is, to reduce a significant risk of material health impairment or grave danger to an employee, the Act gives the Secretary almost unlimited discretion to devise a means to achieve this congressionally mandated goal. And it cites something from the DC Circuit Court in 1981. Almost unlimited. This may be the limits, though. As standard individual requirements need only be reasonably related to the purpose of ensuring the safe and healthy working environment. Yeah, that's kind of my major point. They need to be reasonably related, but reasonably related to what? The work environment. The work environment. We need to make sure the work environment is safe. Install that railing. Make the steps this way. Wear these kinds of shoes so you won't slip and break your head open. And so forth and so on. OSHA's authority stops outside the work environment. OSHA has no authority outside the work environment. But now suddenly they're regulating standards that go outside the work environment. Do you see the problem? Do you see the issue here? The OSHA Act in Section 6C1 says the Secretary shall issue an emergency standard upon a finding it's necessary to address a grave standard. So I had to do this. In particular, the Secretary shall, without regard to the requirements of Chapter 5, Title 5 of the United States Code, for an emergency temporary standard to take effect immediately upon publication in the Federal Register if they make determinations. So there's other parts of the code, and I believe Title 5, if memory serves correctly, is part of the Administrative Procedures Act. So basically, you can ignore parts of the Administrative Procedures Act if this is true. The employees are exposed to a grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards, and that the agency standard is necessary to protect employees from this danger. A separate section of the Act, Section 8C, authorizes the Secretary to prescribe regulations requiring employers to make, keep, and preserve records. So this is going to be part of the keep records and prove your records. This is going to be part of the papers, please section when we get there. So, you might want to pay attention when we get that far. Section 8C also provides the Secretary shall require employees to keep records of and report on work-related deaths and illnesses. Well, that's just true generally, by the way. They're just generally required to do that. If there's a death or injury at work, they have to report to OSHA. This is true. The provision exempts the Secretary from procedural requirements contained in the OSHA Act and the Administrative Procedures Act, including those for public notice. So we can put in place, because the normal way you would do this is with a non-final regulation, right? You normally put in place a non-final regulation that doesn't have enforcement power, request comments, and then revise that and put in place a final regulation that does. So rather than put in place the non-final and then final, we've come up with a new scheme. Temporary final and final. And they're both binding the moment they drop the desk. So for those of you on the East Coast, this is law as of 2 hours from now. So enjoy your last 2 hours of this not being a thing that exists for you. The Secretary must issue this in situations where employees are exposed to the grave danger and immediate action is necessary. By immediate, we mean basically 2 years after the fact, apparently. The determination of what level of risk constitutes a grave danger is a policy consideration that belongs in the first instance to the agency. So that basically is saying, in so many words, Chevron. That's saying Chevron. What is a grave danger? Because it says, the law says they can issue it in grave danger. What does grave danger mean? I'm so glad you asked. That's up to the agency to determine. It means what the agency wants to mean, even if they change their mind. They get to make the determination. It's grave because they say it's grave. Chevron, Hour, Brand X. Those of you who are regulars know exactly what I'm talking about. However, a grave danger risk represents a great risk greater than significant, you don't say, that OSHA must show in order to promulgate the permanent standard. In determining the type of health effects that constitutes grave danger, the Fifth Circuit emphasized the danger of incurable, permanent, or fatal consequences to worker, as opposed to easily curable and fleeting effects on their health. Although findings of grave danger and necessity must be based on evidence of actual prevailing industry conditions, when OSHA determines that exposure to a particular hazard would pose a grave danger, OSHA can assume exposure to a grave danger whenever that hazard is present in the workplace. I love it. I love it so very much. Okay. OSHA is required to find actual conditions. By actual conditions, we mean theoretical conditions. Chevron. In determining whether OSHA has shown this, a Fifth Circuit considered whether OSHA had other available means of addressing the risk that would not require it. Additionally, a standard must be both economically and technologically feasible in order to be reasonably necessary and appropriate, and by inference necessary. On judicial review, OSHA is entitled to great deference on the determination of grave danger and necessity. Judicial review of these legislative determinations require deference to the agency. This should sound very, very familiar. Very familiar to longtime fans of the channel. This is not the first time you've heard this kind of language. The duty of courts of generalist judges is to merely patrol the boundary of reasonableness. And by reasonableness, we mean a lot. These determinations are essentially legislative and rooted in inferences from complex scientific and factual data. The agency is not required to support its conclusions. The agency is not required to support its conclusions with anything approaching scientific certainty, and has the prerogative to choose between conflicting evidence. Yeah, we're not required to be scientific certain. And if there's conflicting evidence, that's okay. We can just choose the evidence that supports our conclusion. That's literally what that means. That's literally what that means. There are many studies saying many different things. These studies are confusing and bewildering. How do we solve that problem? Aha! We pick only those studies, and exactly those studies that say what we want them to say. How convenient. And then given those studies, we promulgate a regulation based on that information that we self-selected. The determinations of the Secretary in issuing standards under Section 6 of the Act, including the emergency regulations, must be supported if substantial evidence in the record is considered as a whole. The Supreme Court has described substantial evidence as such relevant evidence as a reasonable mind might accept as adequate. Do you see? I just love how, like, mealy-mouthed this language is. Okay, substantial evidence means such evidence as a reasonable mind might accept as adequate. That's a lot of qualifiers there, man. You might accept it. It might be adequate. It just have to be reasonable. This is why this is a lot of latitude. This is a lot. If it sounds like a lot of latitude, it is a lot of latitude. You are not misunderstanding it. And as we know, I'm going to keep mentioning Chevron a lot. As we all know, this is not the only example of this. The agencies get buco latitude. They get disturbing amounts of latitude sometimes. If the Supreme Court, incidentally, wants to use this as a basis to restrict Chevron, I will be happy. I'll be very happy. That would just be the ultimate. That would be the ultimate win for me in my dreams. In my dreams, if this gets to the U.S. Supreme Court and they use this as a basis to constrict Chevron, you'll see one of the happiest uncivil laws you've ever seen. The court has also noted that the possibility of drawing two inconsistent conclusions, this is good. The possibility of drawing two inconsistent conclusions from the evidence does not prevent the administrative agency's finding from being supported by substantial evidence. So what does substantial evidence mean? Well, substantial evidence means that a reasonable person could draw two completely different and mutually incompatible conclusions. The evidence is such that you could draw two different and mutually incompatible conclusions. That's okay. Just pick your favorite. Although Congress waived ordinary rulemaking process in the interest of permitting rapid action to meet these emergencies, Section 6, I never said it was okay. I'm just telling you what the reality is. Section 6C of the Act requires OSHA to include statements of reason for action when it issues any standard. Well, that's not going to be hard given these standards. By requiring the agency to articulate its reasons for issuing it, the requirement acts as an essential safeguard to an emergency temporary standing setting. However, the Third Circuit noted that it did not require for every substance, type of use, or additional technique, but rather a general explanation. So we don't need, so basically what that says is if we're requiring you to do a multitude of things, like, for example, wear masks, socially distance, put up barriers, get the vaccine. If we're requiring you to do multiple different things, we don't have to provide a reason for each of those things separately. Why would we do that? We just have to provide a reason for general. And the general necessarily implies the specific, don't you know? ETSs are by their nature designed temporary. Well, that much is true. It is temporary, but it can absolutely manifest and mature into a not so temporary regulation. So the ETS itself is very technically temporary. You are correct, sir. It won't matter, but yes. Under the law, the ETS serves as a proposal for the permanent standard, which is less temporary. And the Act calls for permanent standard to be finalized within 6 months. The ETS is effective until superseded by this standard. So they have 6 months. They have 6 months to promulgate a final rule. So your guess is as good as mine if they wait till the last day or they basically do something immediately. Do they wake up essentially tomorrow and be like, oh yeah, by the way, new ETS for the under 100? Or do they wait till the last minute and then do it? Your guess is as good as mine where in that 6-month interval it will be changed. Of course, I would be a bit remiss if I didn't point out that it's possible for the ETS to simply be withdrawn. Ha 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 ha. Yes, I'm sure that will happen. When OSHA issues a standard pursuant to law, whether permanent or temporary, Section 18 of the Act provides that the standard preempts any state standard. Well, that's fair enough. Federal law always supplants state law. Welcome to federalism. A state can avoid preemption only if it submits a plan for development and enforcement, which must be at least as effective. So if they can go further, then fine, which is generally the law with respect to federal-state interactions. However, the OSHA Act does not preempt state laws of general applicability that require workers and non-workers alike, so long as they do not conflict. Yeah, so that just basically says you can do things outside the OSHA Act. So you can require employees to do other stuff, presumably not necessarily even safety related, just like clock in for the day, as long as it doesn't conflict with anything in the OSHA Act. As discussed detail, OSHA has determined that a grave danger exists. Yeah, we covered that. And compliance with it is feasible for the covered employees. OSHA has also provided a more detailed explanation for each provision of this. In addition, OSHA wishes to provide here some general guidance on legal regulatory authority and for particular provisions. Well, boy, I hope this is going to be helpful. Now, what your friend Uncivil Law is hoping to see is some fairly specific stuff that would help inform this discussion about the specific things they're relying on and precedent. That would be nice. Then I could pick apart those specific things and discuss whether they do or do not apply to the situations. I don't know all the laws because they're about to inform me of some of the laws, right? So I don't know everything. I don't know all the case law that exists. So maybe there's cases out there, for all I know, that would stand for some of these propositions. I don't know. I would love to learn about that. That would be great. What I fear I'm going to have is very general authority thrown in my face. My working guess here is I'm not going to have I'm not going to have the electrolytes that the plants crave. I'm not going to get some case that stands for a specific proposition and then by reasonable analogy extrapolate it to the current situation and be like, okay, I can see how this thing reads on this thing. That makes sense. Good job. My guess is I'm going to see some very general stuff that doesn't speak to anything specific. Let's find out if I'm right. As a threshold matter, OSHA's authority to regulate exposure is well established. Really? Section of the OSHA Act uses similar language. A former sets forth requirements for promulgating standards addressing toxic material or other harmful substances. I don't even know that strictly speaking you can really qualify. Can you really strictly speaking classify COVID as a toxic material? I mean, it's not a material because it's nature. Well, even if it was produced in a lab or augmented, it's natural enough. It's not a material. And is it a physical agent? It's not like a chemical that will do things. Does COVID work for either of these? This is the wonderful part of being a lawyer. We stretch definitions until it works. So yes, it's a toxic material because reasons. Indeed, exposure and medical records access regulation, OSHA has defined toxic material or harmful agent to include any biological agent. Well, okay, there you go. That's the answer to that question. So yes, it is, because we said so. In addition, and regarding previous exposure, as a new and physical agent, OSHA has also previously regulated hazards like COVID-2 as health hazards. For example, bloodborne pathogen standards, that's not like this. This would deal with like blood being spilled at the workplace. If the blood contains disease, then we have to have standards for cleaning up the blood. And people get hurt at workplaces, both employees and customers alike. It happens. So we should have standards for how to deal with that. Fair enough. But even then, we're still dealing with it in the context of the workplace. So if you get hurt at the work and you start dripping blood all over the place, yeah, OSHA cares because now the blood is in the workplace. They don't really so much care about the blood that's in your body when you leave the workplace. This BBP standard was upheld, which observed the infamous character of regulated bloodborne diseases might warrant more regulation to be necessary in the case of a non-communicable disease. Fair enough, but still the nature of the exposure is workplace specific. In addition, the preamble to the respiratory protection standard, which also is workplace specific, OSHA emphasized that respiratory protection standards does apply to biological. Yes, but you only have to wear the respirator while at work. In addition to being a physically harmful agent, COVID is also without question a new hazard, as discussed in more detail. It was not known to exist until January 2020, and since then, 725,000 people have died in the U.S. We're not going to be able to read all this, by the way, because it's 490 pages. A lot of that's going to be like probably previous comments and stuff. So we'll get through at least the executive summary. And after that, So for those of you who are wondering, how long is it going to take to read this? Yeah, that's not happening. The entire regulation is 490 pages long. So we'll read the executive summary and go from there. Turning to specific provisions, the vaccine requirements in this are well within OSHA's authority. Please tell. Vaccines can be a critical tool in pursuit of health and safety, particularly in response to infectious disease. See Jacobson, which regarded smallpox vaccine as a reasonable measure to protect public health and safety. In the case of a state-based regulation, Klassen, citing Jacobson and noting vaccination may be appropriate as a matter of a state-based regulation. And the OSHA Act itself explicitly acknowledges that such treatment might be necessary in some circumstances, providing the Act's provisions on research related to activities conducted by Health and Human Services to aid formulation of standards. Standards that nothing in this or any other provision of the Act shall deem to authorize or require medical examination, immunization, or treatment for those who object to on religious grounds, except where such is necessary to the protection of the safety and health of others. So much for your religious reasons. Goodbye. That's also consistent with Jacobson, which, as again, reminder, is a state law-based decision and doesn't necessarily cleanly read onto the feds, because federalism. In recognition of health and safety benefits, OSHA has previously exercised its authority to promulgate these vaccine requirements in COVID healthcare cases and the BPP standard, which is the bloodborne pathogen. The bloodborne pathogen standard illustrates congressional understanding of the statutory authority to issue standards for vaccine provisions when appropriate. What? Additionally, OSHA's authority to require employers to bear the cost of these provisions is solidly grounded in OSHA Act. Well, to the extent that they can do it, then yeah, because employers have to pay for all kinds of stuff. They have to pay for, the harnesses and the safety vests and the railings and so forth and so on. So yeah, if you accept the underlying premise that this is a valid regulation, then yeah, sure, getting employers to pay for it also would follow. That makes sense. The Act reflects Congress's determination that costs of compliance are part of the cost of doing business. I mean, fair so much as it goes. It relies on some other predicate assumptions, though. Consistent with this authority, OSHA has largely required employers to bear the cost of this, including typical costs of the vaccine. The allocation of vaccine costs to employers is similar to that of costs related to other things. I'll take your word for it. The OSHA Act provides OSHA with discretion, however, to decide whether to impose costs, such as those related to medical examination and tests, on employers when it determines those costs are appropriate. OSHA has determined that for the purpose of the emergency regulation, it would not be appropriate to impose it on the employers, any costs associated with the testing for employees. So the employers, if you want to be exempted, you have to get tested, you have to pay for it. Your employer doesn't have to pay for your testing or your masks. They have to pay for your vaccine, which is free incident anyway, but I have a COVID warning from YouTube. Fun. That's great news. Not that it matters, because who was it who got a strike? Was it Nick Ricada? I don't think it was Nick. I think it would have been, was it Eric Hunley? Somebody got a strike for reading stuff from the CDC's website, even after appeal, because apparently they were spreading vaccine misinformation. Once again, they were reading it directly from the CDC's website. I'm also reading an official government document for the value it will save me. I don't know who it was. It was somebody, but whatever. Anyways, where was I? However, explained elsewhere, the safety regulations are best effectuated by vaccine, not testing. Accordingly, only requires employers to bear costs of the compliance with the preferred and most protective vaccine, but not costs with testing. You pay for it yourself, heathen. The agency does not believe it be appropriate to impose costs of testing on employer when employer has made the choice, the individual choice, to pursue the less prudent option. Yeah. For the same reasons, the OSHA has also determined it's not appropriate to require employers to pay for face coverings. Pay for your own face covering, heathen. Finally, the Act and its legislative history both demonstrate unmistakably the authority to require employees to temporarily remove workers that prevent exposure. I mean, right. I mean, that makes sense, right? Does the employer have the authority to remove workers from the work site in response to a dangerous condition? Yeah? You know, there's a dangerous condition. How about leave? That would be a reasonable thing for the employer to do. Oh, look, the chemicals are spilling. Whatever shall we do about it? I don't know. Maybe everyone leave would be a good idea right about now. You'd be happy to know that that's legal for the employer to do. Great. That's helpful. And again, this authority OSHA has repeatedly exercised in prior things, including whatever. It's equally appropriate for all those reasons here. Okay, so we're going to go through the rationale. I'm not going to go through a detailed explanation of grave danger because, as we kind of discussed, because of the amount of they're going to go through reasons. They have to defend the castle. It's just not very hard, right? They have to defend the castle. It's just not very hard. They have to put up the equivalent of a stop sign, or maybe a little bit more, but not by much, right? So they have to provide reasons, but they just don't require a lot. I'm sure they'll provide more than enough reasons. It's not hard. It's not hard because the standard is so low. So why read it? I know they met it. It's not hard. I have every confidence they met it. They're going to go on for pages and pages to explain it in extreme detail, but why? For us. Skip. Blah, blah, blah. Some more blah, blah, blah. Even more blah, blah, blah. I'm waiting to get to section 2, by the way, where we're going to discuss some law, I think. I don't care about the factual findings. I'll assume that they have it. Someone else can fight over the factual findings. That's just not my interest. I care about law, remember? Blah, blah, blah. Some more blah, blah, blah. Talk amongst yourselves. While I was scrolling to find this. We're not going to read the whole thing, incidentally, even when we get to the legal section, because it's just going to be too onerous. But we'll skip around and see if we can find some stuff that provides some basis for intelligent commentary. We'll see if any of their legal authority strikes me as any good for any of these propositions. You never know. Maybe they've got something. Change my mind, as Steven Crowder would say. You might have it. And then they cite some authority. Need for it. Scroll some more. I could just go back up to the edge and find out what page it's on, but I'm just going to continue scrolling until we get to where I care about. Okay, yeah, there's nothing else we could do other than this. Sure, that's fine. I'll take your word for it. It's not hard to meet the goal. I'm sure you're there. Someone else can attack it if they. I mean, this isn't to say that people won't attack the factual basis. They might even be right. It's just not my primary interest, right? So we'll let someone else deal with it. All right. So now we get feasible. We're still in section 1. Where do we pick up the legal authorities? Other than the OSHA Act and Jacobson. OSHA Act doesn't really do it for you except by general reference, which leaves a lot to be desired. And Jacobson doesn't do it for you because it's state level and this is federal, and that's different. Federalism. Ability of supplies, Christ. Access to testing in underserved communities, blah, blah, blah. Economic analysis. We think it's going to be economical. It's not our money. Sure, why not? Teleworking is an available option. Some other things. The effect of this. Ben Shapiro is suing. I saw that. Good luck to him and stuff. Some more financial stuff. Even more financial stuff. We can make them keep records. I mean, yeah, fair enough. The records are going to be pretty intimate. I mean, with respect to the employees specifically, but sure. We can make them keep records. Yeah, that's fine. Is there a separate legal section or is it just buried everywhere else? Economic determination. Some more economics. There are a lot of words. Congressional Review Act. Okay, yeah. So there is a Congress can make this go away. I think it goes to the Senate, by the way. I think it's the Senate's determination. So I think Congress, or more specifically the Senate, has the ability to nullify any federal regulation if they do it within a certain time period. So in order for this to work, you're going to have to get some Democrats on board since it's 50-50. But hypothetically, the Congress can stop the agency. Because after all, they are master of the law. So, Is a good law a concise law? This isn't the actual law. This is just providing all the rationales for the law. So this isn't the legal determinations of what you must do. This is just why are we able to do it? Why is it a good thing? Why is it a good thing we're doing this? Here's why it's a good thing we're doing this. That goes on for pages and pages and pages. Executive authorities, state plans, Paperwork Reduction Act. I'm going to have to go back up to the top and see if it provides me a page number. Oh, they're starting to talk about case law. This is dealing with conflicting state law. I think. All right, what page am I on? I'm currently on page 333. Let me see if there's a separate legal section or if it's buried throughout. Because maybe I missed it. Please provide me page numbers. You've got to be fucking me. Okay, hold on. Hold on. Is there nothing? Is it just in the preamble and not in a separate section? Oh. Okay. It's just in the preamble and it's not a separate section. So I'm sure that there's legal authority throughout for the various parts. So I'm sure it appears. It just doesn't nicely appear in the preamble. So up to this, what we read, everything we read was the preamble. Everything we read was the preamble I'm going to say it one more time. Everything we read was the preamble. The preamble went on for a while. Fun. All right. So we're not going to read this anymore. Instead, I'm going to give you my thoughts on the legal authorities on the issues best as I can determine. All right. So as we discussed, and as OSHA discussed, they have the general authority to make workplaces safe. They in Section 5A and 5B, it gives them very general authority, very broad authority. The employer is required to make the workplace safe. Employees are required to conform to the requirements that make the workplace safe. Basically that, right? If employers don't make it safe, the employers can get fined. If the employees disregard the things that make it safe, the employees can be fined. So incidentally, for all those people who are like, I'm just going to defy this, and my employer has to pay a fine, that's true. You know who else has to pay a fine? You do. So if you're just going to be like, oh, I'm just going to defy this, you're going to have to start writing some checks, just to let you know. And you're going to have to pay those checks while the thing's being fought over, probably. All right, but let's talk about, can OSHA do this? So OSHA has a very general authority to do the stuff in the workplace and make workplaces safe. This applies to all kinds of industries, and the amount of regulations that OSHA has goes on basically forever, because there's any number of workplaces that have any number of stuff. But I've given you some examples. Wear the hard hat, wear the high visibility vest. Make sure there is a railing to prevent you from falling off the edge of a height. Make sure the stairs are this way, and make sure there are fire extinguishers and other things like that. And then it goes on to pages and pages and pages and pages and pages and pages and pages of very specific detail. And as I was talking about this with Stephanie, who is an OSHA person who we had on our channel recently, pretty much every specific regulation is there because someone did a stupid. I feel like they should have footnote credit. Credit to this guy who did this stupid thing. So if you're ever reading a regulation and be like, why is there a regulation on this? It's because someone somewhere did a stupid. And OSHA had to create a new rule because people are endlessly creative in being idiots. They find new ways to be stupid. So they keep having to come up with rules to deal with the new ways of stupid. Anywho, that's beside the point. Obviously, they have general authority to deal with contaminants in the workplace, but here's why it's different. The nature of the mandate in place is a requirement to do something to your own body internally, right? It's not please don't get blood on my floor, and if you do, we're going to clean up the blood, and also you have to put on a bandage and stuff like that, right? It's not that. It's not wear the mask for the dust so you don't breathe dust. And that only is in the workplace, right? The problem with it is it's requiring you to do something internally into your body, which is pretty unprecedented. It's requiring you to do something medically to yourself. That's kind of a problem. And yeah, that's an issue. So it's an issue because OSHA nowhere in any of its regulations, nowhere in any of its regulations does it have anything dealing with anything that's comparable to that. All the things that they deal with are related to problems that would exist or do exist in the workplace. The problem with this is requiring you to do something to yourself internally, medically, that necessarily follows you as you leave the workplace into the broader wide world where OSHA doesn't have authority over you. So that seems odd. And the testing requirement that's currently in existence, but if you're saying to yourself, what's okay, I'm not required to do something medically because I can just do the testing and I can just do the face mask, sure, at your own expense, and incidentally, I wouldn't bank on that being true in the final rule. I wouldn't necessarily bank on the mask testing exemption continuing to survive. So it may be here for a brief time. So the problem, of course, is OSHA doesn't have general authority to regulate health in general. That would be, very unsurprisingly, the province of the Department of Health and Human Services and the CDC. And even they don't have authority to do all the things health-related as we discussed during the rent stuff. So their power is limited, but they deal with the general health stuff. OSHA does not deal with general health. They more specifically do with general safety, not health. Or to the extent they do, it's workplace specific. CDC goes beyond those terms. Department of Health goes beyond those terms. So part of the problem is that OSHA, by its regulations, is seemingly encroaching on areas that have already been designated to other agencies, which seems like a disfavored interpretation, right? The interpretation I want is already something some other agency has. That seems like an odd interpretation just from that principle. But the more specific problem is that this federal government does not have the general authority to regulate health from a federalist constitutional perspective. It is the states, not the federal government, that have what's called police power. Police power is the general power to do things in general, the general power to regulate, the general power to make laws, and so forth and so on. States have the general residual power to make all the laws that are compatible with the Constitution. But the police power in the first place, the Constitution obviously provides exceptions to this. But let's just talk about what the police power is. The police power unto itself is the power to make all the laws and all the regulations you can dream. That's the police power. It's the power to regulate all the things. It's the power to make laws on all the things. And then, of course, the Constitution takes away some of that power, thank God. But they still have the general power to do all the other things. Right? That's state-level power. So Jacobson is a state-level case. It came out of Massachusetts. More specifically, it came out of Cambridge, if memory serves correctly. There was a spread of smallpox, which has a 30% death rate. So there's a difference there. The city of Cambridge passed a regulation that required every person who didn't have a health exemption, so no religious exemptions, no personal consciousness exemptions, only health. Required every person, I think above a certain age, but don't quote me on that part, to get the vaccine or pay a $5 fine, which in today's money is somewhere between $130 and $150, depending on which of us legal scholars you ask. So not a huge burden. And now, by the way, the fine has gone up from $150 in modern money to $1,000 for the person and $10,000. So there's that. But Jacobson deals with state-level authority. So you can't take Jacobson and just simply say, oh, the federal government can do this too. That's not how this works. The federal government doesn't have police power. It is a body of what we call enumerated powers. The federal government only has as much power as is mentioned in the Constitution, which may be extensive and may be broad, but is nevertheless limited in the sense it isn't all the things. Right? So the power they have may be sweeping in some respects, but it's not all the things. It's only the things that we gave them in the Constitution. So the general authority to regulate health is still a state-level province, particularly where there's no federal law that's specifically on point. Could Congress preempt the field? Actually, that's an interesting question, because they'd have to basically hijack all the state health authority, and I'm not sure that's possible, but maybe. But this isn't an act passed by Congress now, is it? Congress didn't write anything new. They just interpreted power out of existence, which, once again, they can do because of Chevron. They can just interpret things in a new and exciting way and grant themselves new and exciting authority from nowhere. It's wonderful. It's just wonderful. So, where was I? Yeah, it was in a congressional act, was my point. So, I think now I'm sure other people will come up with other legal arguments. So, for example, Ben Shapiro and his suit, I don't know if he's going to go in this direction or not. I don't know what his arguments are, and I don't know if anyone else has a better argument. I'll tell you the best argument I got. The best argument I've got is that it exceeds outside the workplace, and OSHA doesn't have authority outside the workplace. So it's basically a twofold argument. The regulation by its very nature influences me outside the workplace, and you can't do that because your domain is inside the workplace. You're also hijacking other federal authority, which is kind of a weaker argument, but still there. You don't have the general authority to regulate health. And the general grant of authority you do have can't be read to something that specific. So and those are kind of the arguments I see as working, or the best arguments I see as viable. And then, of course, there's the possibility that there's some sort of procedural defect with the proposed rule. So they didn't follow some provision of the law. They think they did, but someone could quibble over that. They don't have enough factual support, which seems like hard to believe, but I guess theoretically possible. So there could be something defective with the actual instrument itself in that way, but I wouldn't bank on that. But the idea that they don't have the authority to do this because they don't have the general authority to regulate health, they don't have the general authority because states have the general authority, it impacts you outside the workplace, and the nature of the threat is outside the workplace. These seem like the best lines of argument to my mind. So we'll see if Ben Shapiro or anyone else comes up with better lines of attack. But that's what I've been able to come up with. So, and also there's also the parade of horribles problem, because there's no limiting principle, which is another big issue. Because what is the limiting principle for OSHA, right? So a question from Justice Thomas, if this gets to the U.S. Supreme Court, Justice Thomas might ask a question, because it sounds like a Justice Thomas question, and he's asking questions now. Justice Thomas might ask a question like, suppose OSHA determines that a diet of a particular kind is very helpful to employees in a particular workplace because it helps them be more alert and helps them be more physically fit and otherwise helps them to better achieve safety ends. Would it be viable for OSHA to promulgate a requirement requiring employees in that industry to eat that kind of a diet? Right? This is the can they make me eat broccoli though argument, which is still a good argument. In my humble opinion, it's still a good argument. It's like, if they can make me buy health care, can they make me eat broccoli? If they can make me take the vaccine, can they make me eat broccoli? What is the limiting principle here? The argument always is, well, this is extraordinary, which it might be. This is extraordinary. We need this power to deal with this truly extraordinary situation. And oh, by the way, we'll never use it anywhere else again, and we'll never abuse it, and it will never get expanded everywhere, promise. So the question is, okay, let's just assume that you can do this for the moment. Let's just back off a second. Let's just back off a second and assume OSHA can do this. Okay, what can't OSHA do given that predicate? If they can do this, what else can't they do? And why can't they do it? What are the limiting principles? What are the limiting factors? Since you can go outside the workplace, since you can make me do things internally in my own body, such as eating, since you can do, what are the limiting principles that prevent but eat broccoli though? Please let me know. So that's actually a very, very good line of argument too. So that's the best I've got. That's the best I've got. And anyone who says slippery slope, -5 demerits. -5 demerits for anyone who says slippery slope. That's a slippery slope fallacy. No, it's not, you assholes. It's not a slippery slope fallacy. Slippery slope fallacy is saying because something happened, it must be true the next thing can happen. That's a slippery slope fallacy. Because we went this far, we will necessarily go further. Did I say that? I did not say that. I said, because we went this far, why can't we go further? What's preventing us from go further? I didn't say we would go further. I just simply asked, what's preventing us from going any further? That's not slippery slope. So get your fallacies right. So let me answer some questions from the chat. Now that I've been ranting at you and saying Chevron, Chevron, Chevron a lot, let me look at Discord and see if you have any questions for me. As always, to ask me a question, please start your text with either the word question or the @Uncivil Law tag, and it will pop up in the bot, and I will hopefully see and read your question. Let's take a look and see what you've got for me. Joe's Mad said, think it will hold up. Can Congress delegate the power? Did Congress delegate the power? Did Congress delegate it? No. Can they? Maybe. Think it will hold up? Well, I think Chief Justice Roberts would vote for it, but it might. Let me put it to you this way: no one but the Supreme Court is going to really do anything about this. I think. Evil Ash says, "I work product supply for a major food manufacturer. Take a guess." Friday the 13th says, "Going all right. Going after someone in Bloodborne, but headless is whatever is being a roadblock." Joe's Mad said, "Will we see the limits of interstate commerce in this episode?" No, we will not. Scorpion says, "It was such a hazard it would have taken 6+ months." Right. Scorpion says they got to 100 employees the same way they got to 6 feet. That's the actual answer. Scorpion says, "Is it an undue burden to require weekly testing? Assuming it doesn't pay for it." Well, probably, but it doesn't matter. Because, like, undue burden, well, undue burden is only something we get from the abortion cases. So you have the right to make medical decisions for yourself, and no one can interfere with that. So if someone wants to make a Roe versus Wade, Casey versus Planned Parenthood, that you have the right to make medical decisions, and no one can force them on you, and so this must be illegal, that would be hilarious. Ty Burner says, "Do you think this is a way to kill jobs so we have to rely on the government?" I don't know if that's their plan, but, President-elect Austin says the tests are anywhere from $8 to $100, but that's an undue burden. Well, doesn't matter. Suck it up, commie. Matthew says, "Is there any legal topic you won't be live streaming about today?" Well, yes, as a matter of fact, I didn't find time to live stream the NRY SRPA oral arguments. Too many things happened. I can't keep up with it all. Scorpion says, "Hey, OSHA, fuck you." You can write that to OSHA if you want. Joe's Med said, "At what point, how many years does an emergency cease to be an emergency and just become a normal state of affairs?" Oh, if you're saying an emergency state can last for a long time, potentially indefinitely, you are correct, sir. What was it? Someone said, was it Reagan who said nothing is as permanent as a temporary government solution? The income tax was supposed to be temporary. Honey Badger, so they can have it mean whatever they want to mean without specifying. Well, they have to specify, but they can have it mean whatever they mean. Yes, and they can also change their mind later. Scorpion says a temporary ETS with very permanent effects. Right. Sterling says, "Do I really have to have a religious exemption?" You're not allowed to have a religious exemption. OSHA doesn't allow you to have a religious exemption. It's not there. You have to have a medical exemption. I mean, I'm not religious other than thinking I'm a portion of God, and my personal portion of God objects. Isn't that enough? No, because you're not allowed religious exemptions. A. Henninger says, "You had the warning before you even started." Fun. That was Adam Krigler? Fine. The Matrix has me? Noted. J. Boss says, "Not just reading a document, reading an ordered mandate and trying to explain it. Technically, it's a public service." Right. T. Miller says, "Can OSHA force an employee to buy something?" Good question. Isn't that what Congress forced them to do through the Commerce Clause with the ACA? Yes, it certainly is. It raises very similar questions to the Commerce Clause issues with the ACA. Grimm says, "Is a good law a concise law?" It helps. Devil's Advocate says, "If you're looking for the actual text of the law, scroll to page 473. Okay, let me scroll to page 473 and we can read the actual law, because we didn't actually do that. Well, let's see how long it goes on for. How many pages does the actual law go on for? Oh, Christ. I'm not reading this. Oh, it's actually not that long for the general authority. I think we might be able to read it. Hold on. It's 13 pages. Do I want to read 13 pages? Well, we'll skim the 13 pages. How about that? All right, let's skim the 13 pages of the actual regulation as it applies to general industry. Other industries have other regulations. So it's minimum vaccinations, grave danger. It's required, protects the right of most private employees to take collective action. The scope of it do not apply to the things we talked about. It doesn't apply to employees of covered employers who do not report to a workplace while working from home or who work exclusively outdoors. So this is not to stop necessarily your employer from imposing it on you anyway, but strictly speaking, the mandate does not apply if you're full-time telework. So as long as you're not going into the office or the store, then you don't, by the scope of the regulations, have to do it if they don't want to. COVID-19 test means whatever a COVID-19 test means. It can't be self-administered, though. It can't be self-administered and self-read. Face covering means is made with 2 or more levels of breathable fabric. It's secured to the head with whatever, fits snugly, solid piece. It includes clear coverings or face coverings with a clear panel that, despite the non-cloth material allowing light to pass through, otherwise meets its definition and communicate with deaf people. Face mask means whatever that means. Fully vaccinated means a person's status 2 weeks after completing the primary vaccine process. Mandatory vaccine policy is the policy requiring each employee to be vaccinated. And then it says other than for whom a vaccine is medically contraindicated, that's health. For whom medical necessity requires a delay, that's health. Or legally entitled to reasonable accommodation because of religious beliefs. So that might be a possibility for religious beliefs. So I slightly misspoke earlier when I said religious beliefs aren't a thing. But it has to be as part of a reasonable accommodation process, so it's not quite automatic, but you might have hope. Respirator means respirator. Workplace means a physical location. It does not include an employee's residence, which is good because I work from home, so yay that. Determination of status. The employer must determine the status of each employee. The employer must require each employee to provide acceptable proof of status. Acceptable proof is the record of the immunization from the healthcare provider, a copy of the COVID-19 vaccine record card, a copy of the records documenting, a copy of immunization records from public health authority, or a copy of any other official documentation. And in the case where an employee is unable to provide acceptable proof, a signed dated statement. So at the moment, you can simply swear to it. And by the way, that would conjure criminal penalties if you lie. The employer must maintain a record of each employee's status, and must preserve that proof of status. So in case OSHA comes knocking at your door, they can verify that. When an employee is attested to it and records retain it, the employer is exempt from requirements relating to documentation. Employer support for vaccination. The employer must provide reasonable time for each employee to get it, provide for 4 hours of paid time at the regular rate for this purpose. Time for recovery. Must provide reasonable time and paid sick leave to recover from any part of the vaccine. Testing for employees who are not fully vaccinated. Employer must ensure each employee who's not fully complied with must do the following. Employee who reports at least once every 7 days. So once a week, who reports at least once a week, must be tested at least once a week, and must provide documentation of the test no later than the 7th day following the date on which they last provided the result. So you have to be tested once a week and provide the results once a week. Employer who does not report of that must be tested before being allowed to return, must provide documentation upon return. So you can't come to the workplace if you fail to meet any of those testing requirements or fail to meet any of those documentation dates. And it doesn't require the employer to pay. Employer notification of a positive test, regardless of vaccination status or any other COVID test requiring. The employer must require each employee to promptly notify the employer when they receive a positive test. Immediately remove from the workplace any employee who receives a positive test or diagnosed with COVID-19 until the employee receives a negative test. Face coverings. The employer must assure that each employer who's not fully vaccinated wears the face covering, except when they're alone in a room with floor-to-ceiling windows and a closed door, while eating or drinking, when wearing a respirator or face mask, when the employer can show the use of face coverings is infeasible or cause a greater hazard. The employer must show that face covering required to be worn is worn over the nose and mouth, is replaced when wet, soiled, or damaged. For example, is ripped, has holes, or broken ear loops. The employer must not prevent an employee from voluntarily wearing a mask until the employer can demonstrate doing so would create a hazard. So if you want to wear a mask anyway, they can't stop you. The employer must prevent employees to wear a respirator instead of a face covering, whether required or not. Wow. That's an interesting thing. So if you want to go like hardcore steampunk, they are required to permit you to wear a full-bore respirator if that's the way you want to go. That's actually half tempting. I do it just for the lulz. They have to let you wear a respirator. I love it. I love it so very much. They must not prohibit customers or visitors from wearing face coverings. Oh, so this basically effectively nullifies. Well, no, it doesn't require the customers to. They just can't stop them to. Fair enough. Which might nullify some state laws, incidentally, but yeah. Yeah, I say if you're going to do it, you might as well go full in. You might as well go in, man. Wear that respirator, man. You know, that's actually not a bad idea as an effective form of protest. I'm gonna wear that respirator. That might be fun. You have to report stuff to OSHA, availability of records, publication of the record. Okay, so we got all that stuff. So basically, it's what we would have thought. So we covered all that stuff. So great. Where was I? I was reading your questions. A remote employee, KZ said, a remote employee is exempt. Though they're exempt from the mandate, yes, but that doesn't prevent your employer from mandating anyway. Studio Rob says, I'm sorry for your pain. Devil Advocate said, yes, everything you read was the preamble. The actual text starts with page 473. Well, that's not quite right. The other stuff is reasons and justification and rationales. Does it include work from home employees? No, it does not. Not for the least of reasons that your home is definitionally exempted. So that's nice. If an employer can require you to change your body to remain employed, then can someone fire a female who's pregnant and refuses to get an abortion? No, no, they can't, because that would be a violation of Title 7. Yeah, you can't fire a female who's pregnant. Scorpion 142 says it's never not a true slippery slope with government. Jordan Farley says, how does this apply to a 1099? Good question. How does it apply to a contractor? That's a good question. Let me see if it says anything about the issue one way or another. I would assume it doesn't apply to contractors, and I would assume it doesn't apply to contractors except in so much as those contractors themselves work for a business that would be covered. So if you're a personal contractor, like it's just you, then it doesn't apply to you. If you're a contractor in the sense you work for a company that works for other companies, then you'll be covered if your company is covered. I don't know if any of that made coherent sense. Joseph said, bro, need a stickers maybe? Love what you do. The Snickers and lack thereof is not my problem. SS, so you think the mandates are counter to collective bargaining? It doesn't matter. Collective bargaining still has to be consistent with the law. A change in working conditions of continued employment without collective bargaining, no injunction. Yeah, the thing is that the collective bargaining has to be compliant with the law. Like, you can't contract to illegal things. Collective bargaining is the ability to agree upon a contract with the union, but you can't contract to illegal things, and the government gets to determine what is and is not illegal. So I don't think collective bargaining comes into it one way or another. Avalama says, bureaucrats write many laws that can be enforced. How's this one different? I don't know. It's scarier. Question, do you think OSHA should exist at the federal level? Probably, because some states would be completely remiss without it. It's probably a good thing. Section 142, it'd be a bad idea for me to write FU to OSHA. I need top secret clearance for any job I apply for. I'm not sure writing FU to OSHA would get your top secret clearance revoked, but you'd be better able to equip the probabilities than me. Ricardo says, well, OSHA is three of 7 on these rulings. I'm not sure what you're referring to, but fair enough. SS says, if this was some lefty issue, the judge and venue shop and have their injunction. One person, irreparable harm undone. Many cases, no injunction, yet stopping this nonsense. Oh, I have no problem, no doubt believing there's going to be venue shopping. I have no doubt some court somewhere is going to issue injunctions. But ultimately, this is a U.S. Supreme Court thing. Killdozer says, careful with that language, you're starting to sound like Greta Thunberg. That was kind of by design. Peter Siegel says, my issue is the government can't ban abortion because it violates a woman's privacy rights by opening their medical records, which isn't the reason, by the way, but it just violates their privacy rights. Wouldn't vaccine mandates be similar? Logically, yes, but yeah. Will this even overcome the rules for an ETS? OSHA has a shit record. I don't know. There might be defects in the instrument, but I don't have the mental energy and bandwidth to analyze those questions. So there might be something wrong with the mandate on its own face in terms of its issuance. So there might be a violation of some rule or something. I just am not going to try to figure that out right now because, yeah. What if a female's pregnant but unvaxxed and doesn't want to wear a mask? Well, then she can't come to work. Do you think TSA will freak out if I wear a respirator at the airport or plane? This only applies to workplaces. So unless you're a stewardess, I don't think this covers you if you want to wear a respirator. But I don't know if TSA would freak out or not. Devil's Advocate says, go to 341. You'll find a breakdown of who counts. And no, independent contractors do not count. That makes sense. Unless they themselves count through their own employer. Monroe says, I work for a large third-party medical biller and haven't heard anything about getting the vax yet. Any idea why I haven't or if I will soon? Well, the reason you haven't is because the mandate didn't exist till today. Well, strictly speaking, technically, it doesn't exist till tomorrow. And it doesn't go into full force and effect until January 4th. So I would expect you'd start hearing things about it in the relatively near future. The Third Circuit in Butler versus Wolf ruled the case was moot. I don't remember what that is, to be honest. Is that might be one of the base judge, but I don't remember off the top of my head. Uncivil law says, I mean, if you've already contracted, it's almost an ex post facto punishment. But it's not punishment, you see. I mean, legally, that's true. Ken's Counseling Couch says, will we ever see the end of nationwide injunctions by district courts? I don't know. The fact that district courts can issue these nationwide injunctions is concerning. In every case, it's concerning. Grim Barr says, could an employer require that any females who work for them take a birth control shot? No. No, you can't do that. No, you can't interfere with a woman's decision to get pregnant. Employer. No. That's just a no. Okay, so those were all the comments and questions you had. Sterling says, this is such a great channel. The guy's amazing. Aw. Thank you. I try. Love you, Uncivil. You're cheeky. Aw. Nice things. I appreciate the nice things being said about me. Thank you for elevating my ego. Yeah, base Judge Stickman the Fourth. I thought that might be the case. Yeah, so he didn't get overruled. It was just ruled as moot. So yeah, he didn't get whacked by the Court of Appeals. That's cool. If I could convince just one person to get vaxxed, it's worth it. Yeah, I have no objection to people trying to convince people to get vaxxed. I've said that I've gotten vaccinated. I've said it's a generally good idea, in my humble opinion. Based on my reading of the research and trying to be as thorough as possible, although I don't have any particular medical expertise, but trying to do my due diligence, I determined that it was a good thing to do. Not for least of reasons, because I have some elevated risk factors. that needed to be considered. So I have no objection to telling people get the vaccine. You should is probably a good idea. I have objections to the mandates, especially when they come from the government. Amy says, you're a really awesome sauce on civil law. Thank you. Jay says, what about temp agencies? I technically work for them. Company I'm placed with is too small to fall under OSHA. You technically work for the temp agency. Yeah. So, I guess the question would be, do you go to the temp agency at least once a week? So I don't know, but I think this doesn't apply to you, but don't hold me to that. Also, there's nothing stopping your temp agency from requiring it as a condition of employment. Thank you, Critical Thinker, for becoming an advocate. That's very, very generous of you. I appreciate it. All federal employees had to be vaccinated. This is very true. Just wait till long-term effects are figured out. Mandates are wrong. Yeah, mandates are wrong. I do agree with that much. Oh, by the way, for those of you who are asking, I don't think I'll produce a separate... I might produce a separate post about it in Community tab, but I'm not going to be doing a video today on the Kyle Rittenhouse trial because I didn't watch it because of all the other things that were going. It was a very busy day involving a lot of streaming for me. I spent a lot more time on the Ahmaud Arbery stuff today than the Kyle Rittenhouse stuff today. By the way, in the Ahmaud case, we do have 2 sets of competent lawyers, so that's nice. They're starting their trial tomorrow. So I didn't have time or bandwidth to do the Rittenhouse thing. I did hear that Grueller gave some really good back chat to the prosecutor, but I hear that the defense is continuing to suck. The defense is not objecting to things. The prosecution's still feeding answers, and all that stuff, and it's kind of still sucking at narrative. So he was able to get some really strong points, but that wasn't really because of him. Actually, now that I mention it, it wasn't because of him at all. It was the prosecutor that somehow got it out of him with this. You don't know what his intent was. Well, he said "F you" and reached for the weapon. That was a nice moment. So no credit to the defense attorney on that one. Somehow that was an unforced error from the prosecutor. You know what the problem was? He asked the one question too many. It was one question too many, and he got burned. So what I hear is the defense lawyer continues to suck ass. He's continuing not to object. The prosecution's continuing to feed answers, and there's a moment of brightness once in a while, but overall the defense case is sucking. This is my understanding of what's going on. It was straight wins for the defense. Well, I heard it was lightly more moderated, but I'll take your word for it. I mean, I didn't watch it, so, Peter Passenger says, Evil says, Stella says, how am I doing? I'm doing fine. Evil Ash says, 2 sets of competent lawyers, whatever could you be implying? Kyle Rittenhouse, yeah, exactly. Peter Shaming says, can people who don't agree with the mandate move to an island? If it's not under the jurisdiction of the United States, I guess. President-elect says the Kyle case was straight W's. I'm glad to hear that seems to be the information. Yeah, Richard sucks, yeah. And I saw this too. As I was sort of trying to blip in and blip out, I did see, I think Nick Recato said that the judge continues to be the best defense attorney for Kyle, which is a lot. That's really funny. No liability to the employer. I don't know if that's true. I don't know if it's true that there's no employer liability. Don't hold me on that. I don't know that's true. Are you saying Barnes should have been there and said, what I'm saying is, I'm not a trial lawyer, and I should have been there instead. It's like there are some real basics that are being messed up. I really shouldn't feel like, it shouldn't be that hard to be better, because all I have to do to be better is do a thing. Just a thing. Object occasionally. I would automatically be better. Just by objecting occasionally, I know the rules of evidence. Just by objecting occasionally, I would be better. I know the rules of evidence. I can do it. It shouldn't be the case. It should be the case where I feel like, yep, I'm ready to take on this murder one trial without criminal experience. I'm ready to take on this case. I'm going to do a better job. But there we are. Sliding Edge says the streams today were getting spicy with those in comments. Too much legal content. No doubt, man. Yeah, even Bittinger was. Even the prosecutor was better for the defense. Exactly right, motherfucker. Even the prosecutor was better for the defense. SS said the judge was on a hot mic. He was upset with the prosecutor and how long one of the witnesses took. Watch today. Bittinger was argumentative, impeaching his own witness. It's never a great sign when you have to impeach your own witness. Impeaching means to undermine their own credibility. It's not great when you have to undermine your own witness's credibility. There are situations where it might be warranted. It's just not a good position to be in. It was at such odds with his two witnesses, he started trying to discredit his own witnesses. That's hilarious. That's hilarious. And the jury can see that, and that might help. So, yeah, Kyle, if Kyle pulls this out at this point, and maybe things will change. Maybe things will change once the case goes on direct. But if Kyle wins, it will not be because of his defense attorneys. It will be because the evidence somehow spoke for itself despite the massive framing problems. The jury was able to look past all that and get to the actual evidence without being so misled. They were able to somehow get to where they needed to be. Or because the judges saves, or even the prosecutor saves. If Kyle wins at this point, it's not because of his attorneys. If his attorneys take credit, I'm going to be sad. And there's still a pretty decent chance that he's going down in flames. You know, there's moments of hope, but is the defense bad enough for a mistrial? Technically, yes. Technically, yes. I mean, that's a really hard trigger to pull, and you don't see judges pulling it often enough, but it is, a judge can declare a mistrial on his own motion. So if he really feels that the defense is really, and I use the word criminally, not in its literal sense, but more figurative sense, if he's criminally underserving his client, technically speaking, yeah, the judge can declare a mistrial and disqualify the counsel. You're horrible. You're not allowed back in. Hire somebody else. Please watch the last 10 minutes. Binger tried to use the FBI to discredit the witness, and Richards saved it hard with recross. Oh, I'm not saying that Richards maybe didn't have a moment of brilliance, but I'm glad to see that he was able to do something that was positive. So that's really nice. SS says, I tend to agree with the witnesses that aren't compelling. Yeah. And I think it's good to play the video and let them talk. I think the Marcy's Law thing is interesting. Can you say Brady? Yeah, Brady. Super Iron Bob says, the last Return on the Cross was short, sweet, and beautiful in Rittenhouse. But otherwise, yeah. Okay, so I'll take a look at that recross and see if the defense lawyer had a moment of brilliance, and then wonder if we can do that just all the time. Yeah, so I'm going to sign off for now. I need a break. But if you've enjoyed this stream, where I've discussed the OSHA mandate and why the government's allowed to do this and why there might be some avenues of attack and so forth and so on, please remember to give the video a like. If you're not subscribed, subscribe. Hit the red button. It's down here somewhere. Hit the red button and subscribe. I did just pass 28,000 subscribers, so that was nice. Thank you to the people who helped me cross 28,000 subscribers. I really appreciate that. That's really nice. So our odds of cleaning 30 by the end of the year are okay. So we'll see if we get to 30 by the end of the year, but I really, really appreciate it. We're going to continue to do what we're doing and try to give good legal information. I'm going to sleep now. If you I don't remember what I was trying to say. Have a good one, guys. Bye.